My guest at this time is Matthew Staver. He is the chairman of Liberty Counsel, and he joins me today to talk about a U.S. District Court judge decision essentially scrapping the conscience protections offered by the Health and Human Services Department through the Trump administration. And as you might expect, it has a strong connection to the abortion debate. And Matt, thanks very much for being with us.
You're welcome. Good to be with you.
Well, let me read directly from the Politico story, which was published on November 6th, that says a federal judge in New York tossed the Trump administration's conscience rule, and they put that in quotes, that would allow health plans and providers to refuse to cover or perform services like abortion, contraception, or gender transition procedures that they oppose on religious or moral grounds. U.S. District Court Judge Paul Engelmayer sided with 26 plaintiff states, municipalities, providers, and advocacy groups like Planned Parenthood, affirming their argument that the policy could threaten funding they've long relied on and drastically disrupt the healthcare system. So this conscience debate has raged for a long time here, Matt. We've seen it in many different incarnations, particularly since the 2015 Supreme Court decision on the definition of marriage. This one has a little bit of a link to that with conscience concerning gender transition procedures and so forth, but abortion seems to be the main motivation for this lawsuit and so forth. So what do you make of the judge's decision?
Well, you know, what we've seen in the last 2 years is more litigation in the courts because of President Donald Trump's policies, his executive orders, or the administration having these kinds of rules that are very solid, common sense, pro-life, pro-religious liberty pieces of legislation or rules. And again, what we've seen is that even though they get struck down more often than not, they often get reversed and upheld on appeal. And I think that's what we're going to see here. What we have seen is the face of judicial activism, and that's why President Donald Trump's presidency is so important. He's now had almost 160 federal judges appointed, and this will change the landscape. This particular ruling is absolutely outrageous. They're not going to lose any federal funding as long as they just simply do what they're supposed to, and that is honor the constitutional protection to free exercise of religion and give accommodation to individuals who are religious objectors, who do not want to participate in abortion procedures or administer abortion-inducing drugs or devices, or who do not want to have their professional expertise confiscated by some government entity and forced into doing gender reassignment surgery, so-called, meaning that they have to amputate healthy body parts for no other reason than that the person wants them amputated. I mean, this is just absolutely insane. When I read this decision, I was livid with it, because how in the world can this judge do what he did other than judicial activism? Really, what we're going to see is this will be appealed, and it too will be overturned.
I want to read you a quote, Matt, from the Attorney General of New York State. Her name is Tish James, and I'll probably have a question about her in general, or actually her more specifically in a moment. But here's what she said. Healthcare is a basic right that should never be subject to political games. Once again, the courts have blocked the Trump administration from implementing a discriminatory rule that would only hurt Americans, unquote. What evidence is there, if any, that someone who, if they still wanted an abortion, couldn't get one because an individual provider had a conscience concern about it?
There's absolutely zero evidence. And in fact, abortion is not health care. Taking the life of an individual who's healthy, a baby, helpless, against their will, certainly is not health care. Moreover, amputating healthy body parts, giving hormone blockers or hormones of the opposite gender is not health care. That's activism. And there is no place to force individuals to violate their conscience. The rule by the Department of Health and Human Services is a common sense rule of religious accommodation. If you go back, for example, all the way to the Civil Rights Act of 1964, it has embedded in it, and from there on out, and even long before, we've had, as part of our culture, because of our constitutional understanding, our constitutional foundation, and the importance of freedom of religion, these are points of accommodation. This was just a place of accommodation. It was Obama that tried to literally obliterate accommodation. And in fact, if you go back a few years, it was the Obama administration that lost 9-0 at the U.S. Supreme Court when it did not want to provide an accommodation for a religious organization. The Supreme Court soundly rejected that. And I think they'll soundly reject something of this nature, too, that this judge has recently instituted. I think there's no question it'll be overturned on appeal. It's just a matter of having to wait longer for this rule to be implemented. Now, this particular attorney general, by the way, in New York, is part of a long list of very activist, radical attorneys general in that state. The previous one started some pro-life litigation. We're still involved in it, having no basis in law or fact, and was chastised by the court when they lost their injunction. That particular attorney general had to resign because of sexual abuse of women, even attempting to strangle them during sexual activity. And so his number two person is now the number one there, and she's just as radical as the previous attorney general. And she's leading the charge on this kind of issue because she's blinded, like so many others, by abortion, by this whole death culture.
One of the things that I think flew a bit under the radar in the 2018 midterm elections was these state attorneys general races. And a lot of folks ran for those positions, particularly from the Democratic perspective, with a specific agenda of confronting the Trump administration. So now that they've been in office for nearly a year, what are you seeing across the country when it comes to some of these left-leaning attorneys general?
Here's what you see in general, and it's very disturbing as an attorney who's been in practice for 30 years now, and that is this. That is the state attorneys general becoming very political and abusing their power simply because they can file suit against anyone and take the power of the state with its unlimited resources and target it against individuals and our constitutional freedoms. And that's what we're doing. That's where we're going. And that's a very disruptive, very dangerous aspect to the foundation of our freedom. What we're seeing with these attorneys general that are from the Democratic Party, whether it's in New York or Michigan or California or in between, they are weaponizing the highest law enforcement agency of the state. They are doing everything in their power to either stop the Trump administration from advancing common sense goals, religious freedom being one of those, or they're targeting, as in Michigan, entities that need to have religious accommodation. The Catholic Charities, for example, that's an adoption agency for decades, and they're trying to stop it now from having any work, any opportunity to place children into homes because they don't want to allow them to have religious accommodation. It's absolutely shocking. It is beyond the Trump administration. It certainly includes these individuals who have lost their way. They no longer have any compass or any moral fortitude to do what's right as an attorney general. They're just there to either obstruct, to stop Trump, or to harass individual citizens because they are either pro-life or pro-family or pro-religious liberty.
Matt, I think a very important takeaway from this conversation is what you mentioned, I'd say in passing, but you're actually quite thorough about it, is that Trump is not trying to change any long-established precedent. He's trying to reinstate the long-established precedent when it comes to conscience protections.
There's no question that President Trump is not changing the precedent. He's just reinstating the precedent that has been there for many, many years and is founded in our constitutional freedom under the First Amendment. What happened during the Obama administration is he rolled back and set aside some of these basic fundamental constitutional principles. All President Trump is doing is reinstating what has been there for years, for decades, from the founding. And what we're seeing is these radical challenges against him by these Democratic attorneys general. We need to have these attorneys general stop weaponizing their offices simply to advance their personal ideological objectives.
Matt, we'll continue to watch. As you've mentioned, it's likely that this decision could be changed on appeal, but we'll see when we get there. Thank you very much for your time, as always.
Thanks. My pleasure.
Matthew Staver is the chairman of Liberty Counsel. I'm Greg Corombos reporting for Radio America.